Good afternoon. My name is Russ Feingold, and I am president of the American Constitution Society, the country's foremost progressive legal organization with more than 200 student and lawyer chapters across the nation. ACS is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers, judges, and advocates, and ensuring that the law is a force to improve the lives of all people. We're focusing our work in the anniversary year on our Constitution's founding failures when it comes to race and equality in this country, and reckoning with our past to create a more just future. If you don't already, we encourage you to follow ACS on social media, including on Twitter at ACS Law. You can also find us online at acslaw.org. There you can join ACS and find more information about upcoming events and opportunities. Now, we could not be more pleased than to be partnering with the LPE Project this year to bring you a series of introductory conversations on law and political economy analysis. This is the fourth such discussion, and if you've joined us before, as I have, you'll know that a growing group of legal scholars has begun to highlight law's role in the perpetuation of racial and gender injustice, the devaluation of social and ecological reproduction, and the violence of the carceral state under capitalism, and to explore concrete legal reforms designed to move beyond neoliberalism and toward a genuinely responsive, egalitarian democracy with critical attention to the need for power and movement building as part of any such transformation. Today, we'll hear from Wayne State University law professor Sanjukta Paul about the law of the platform economy, antitrust, labor, and contracts, followed by commentary from our partner and friend, Yale law professor Amy Kapczynski, who is the faculty co-director of the LPE Project and the co-founder of the LPE blog. They are ready to answer your questions, which you should type in the Q&A box. So Sanjukta, please get us started.
Auspicious beginnings when you don't unmute yourself. Hi, everyone. Really glad to be here. Thank you for that introduction. So I'm going to be talking about the set of businesses and business arrangements that we commonly call the platform economy. And what I'm going to do is kind of, give an introduction, a little bit of a framework. Then I'm going to talk about the legal structure of this so-called platform economy. Then I'm going to illustrate sort of how this concept of the platform economy has been applied in a recent significant Supreme Court case that many of you have probably heard of, Ohio v. American Express. And then I'm going to talk a little bit about what one piece of what a reform program could look like. Okay, so to start, many of the larger social issues that we associate with this set of businesses and business arrangements that we often call the platform economy. And these issues include frequently low pay for various workers who are in the orbits of these arrangements. They include surveillance advertising, issues regarding data privacy, harms to small and independent business, and harm to the functioning of sectors like the press that are important to the public interest and to the functioning of political democracy. Many of these larger issues can be connected in the end to the unilateral power and control that a relatively small group of people have over a large and growing segment of the economy. So this is all probably so far fairly familiar to those who signed up for a talk on the law of the platform economy. So when we approach these issues through the lens of the law school curriculum, the issues tend to become splintered across, just for example, there's certainly more than this, but across antitrust, labor, corporations, employment, labor and employment, and various areas of sectoral regulation, among others. And at the same time that the issues are splintered in this way, they also remain bound together, I would argue, by a kind of underlying common sense regarding the legal organization of competition and coordination. So, for example, one way in which the issues become splintered, some of the issues around the platform economy in labor and employment law revolve around whether workers are employees or whether a particular firm or platform is an employer. These are, legal doctrines within labor and employment law that many of you who are law students are probably familiar with if you've taken those classes in terms of distinguishing between employees and independent contractors, and in terms of the joint employer doctrine, right? In corporations, key issues tend to be framed in terms of whether the board and managers are serving as faithful agents, and we might ask, of faithful agents of what? Whether that's shareholder wealth maximization or whether that's something else. In antitrust, the questions tend to be framed around whether a given act or instance of coordination is pro-competitive. We'll think more about what that means. So even though these issues become splintered across these areas of law that all clearly affect and govern the platform economy, at the same time, I would argue that there's a kind of common sense fabric that underlies these disparate inquiries. And within that common sense, some forms of economic coordination become presumptively favored or even invisible, so that we don't actually see them anymore at all, particularly if they occur, the particular coordination that occurs within the firm, and to some extent coordination that occurs outside the firm when it is lead firms exerting control over smaller actors in their orbits, while other forms of coordination are presumed harmful from the outset. And underlying this, I think, is the idea that competition, so putting aside that question for the moment of normalizing certain forms of coordination and naturalizing them, put that together with the fact that there's a kind of common sense that competition leads to optimal outcomes. This is a common sense that pervades much of the law school curriculum, including in these areas of law that I've mentioned. And we really get this to some extent, from classical and then neoclassical economics, right? So that part of the common sense is supposed to create a normative benchmark for law, right? So the idea is that competition leads to optimal outcomes, and then any distortion of that competitive process leads to less than optimal outcomes. But this normative benchmark, which would define what a competitive price is, what a competitive level of output is, and what would determine, sort of what activities social and economic resources are going to in the first place, and the amount of resources going to particular sectors or activities. That normative benchmark, I would argue, always assumes a certain set of background decisions, legal decisions about what forms of economic coordination are permitted and what forms are not, including, crucially, in the very definition of the organizations, the firms that are to engage in that economic competition. So, and I think this ends up being, pretty important. It might sound sort of abstract, but it ends up being pretty important for policy debate, right? Both for legal analysis, but also for policy debate. So, for example, in labor policy, and in debate about, really in employment law, about, for example, minimum wages and living wages, the existence of this normative benchmark leads to the conclusion that any particular minimum wage or living wage will lead to job loss, right? This is just supposed to deductively follow from this model. In antitrust law, the same normative benchmark leads to the conclusion that any type of coordination outside of the favored ones that I mentioned, and we'll talk about more, leads to a loss in overall welfare. And at the same time, that control of markets by dominant firms is often efficient, a concept that we'll talk about more, because it's presumed to benefit consumers and overall welfare. Right, so this normative benchmark, which sounds a little bit abstract, turns out to be really important and I think central to these really contested legal and policy issues that certainly shape how the platform economy and the rest of the economy are going to operate. So the basic logic of the argument that I want to make, and then we'll talk about it more in the context of the labor platforms in particular, is that economic coordination, and by economic coordination, really that refers to the organization of production, distribution, and consumption. So everything from, the decisions about, what to make, how much to make of it, what to charge for it. These are all, these all count as economic coordination. Frequently, some of these decisions, paradigmatically price setting, are, just presumed to be legal and permissible when they occur within the firm, but to be illegal, and indeed are considered, the Supreme Court has said, the supreme evil of antitrust when price coordination occurs outside of firms, at least when it is done in a relatively horizontal way, right? And so, but the price setting is just kind of the really dramatic example of that, but really all of these other things like output decisions, market allocation, all of these also count as economic coordination. So the basic argument is that economic coordination is always either authorized by antitrust law or not. So for any given instance of economic coordination, and certainly for any instance of economic coordination implicating prices, antitrust is always either explicitly or implicitly asking whether that coordination is justified, and then answering that question one way or the other. And that means that putatively private decisions to engage in economic coordination are always subject to public approval, which antitrust law grants either expressly or tacitly. So, and I would say that, kind of in line with what I was saying before, that law and legal institutions, particularly within antitrust, at times acknowledge this function of, approval or disapproval of economic coordination. An example where it's acknowledged quite expressly is the state action doctrine within antitrust law, whereby action, local or state market governance, for instance, licensing in a particular sector, or some type of democratic price coordination that takes place in a particular market, that would otherwise be considered anti-competitive if it was engaged in by private actors. That is, explicitly something that is licensed, in the sense, not in the sense of a license coming from a federal agency, but in the sense that, this is pursuant to an explicit exemption in federal antitrust law. And so the law is pretty conscious about it. But in various other contexts, and one more thing, in that context, the courts, ask in some way or another whether this form of coordination serves the public interest or not, whether it's purely serving private interests or whether it's only serving public interest. But it turns out that we're quite inconsistent about when we ask that question, about when we ask whether economic coordination serves the public interest or not, or where we just actually assume that it is entirely private and it's fine for it to just serve private ends. And it turns out that actually, somewhat perversely, the more concentrated the power is, the less likely we are to ask whether it serves the public interest. Most of those situations of sort of, of where the state action exemption is applied, often that involves price coordination among relatively small atomized actors. Another example of this is labor unions. I didn't give the example before. So even though, of course, labor unions are legal under existing labor law, they're not, certainly labor unions have been on the decline in the private sector in quite an extreme way in this country. And one of the arguments that, that's sort of in the background, I think, of that political attack on labor unions has been the idea that labor unions are labor cartels and then thus distort the competitive process. So again, there's this selectivity in how economic coordination is evaluated. So where this argument leads is that we ought to make more conscious and overt decisions about what forms of economic coordination we want to permit and promote and which forms we do not want to permit and promote. We are already making those decisions. The argument is that the law is not sufficiently conscious and systematic and rational about it. And we can certainly have a debate about what those criteria should be, but the contention that I would advance is that currently, we're sort of not doing that. Sort of through this splintering across areas of law and then this kind of diffused common sense, we're not sort of bringing these questions, to the fore to debate them and discuss them. And, we'll come back to this at the end in terms of what a reform program might look like, but some criteria we might consider is allocating these rights to engage in economic coordination in a relatively democratic way. Right now, I think we do quite the opposite. So democracy, promoting democracy would be one criteria that we might consider. Another one would be efficiency, but we need to be clear about what we mean by efficiency, right? Because it turns out that in fact this is used in quite an ambiguous way. So we'll come back to that as well. And then consider, what other considerations, you might think about this yourself, what other criteria should we use to allocate economic coordination rights in the economy? Because I'd argue that this really is the fundamental question, whether we're talking about the platform economy or whether we're talking about the rest of the economy. And another implication, I think, of viewing things through this lens is that we come to view these different areas of law in a pretty unified way. So just to take the example of labor and employment, antitrust and corporations, really, there might be some other questions, but a fundamental question that unites all of these inquiries is how are economic coordination rights allocated by these areas of law across markets, but also within enterprises and organizations, which is something that both corporate law and labor law do, right? By determining who the stakeholders in the corporation are, who the managers are the agents of, what kind, who gets a say in corporate governance. And labor unions are another way of allocating coordination rights in a relatively democratic way, both within enterprises, but also across markets once you get to a certain level of density in a particular sector, right? Okay, so with all of that, so let's talk a little bit more about the platform economy. And really the point here that I want to make is that the operation of antitrust law, which I'll focus on now in the platform economy, illustrates in exaggerated form the way that antitrust law and this underlying allocation of coordination rights shapes the economy more broadly. And I'm going to specifically talk a bit about labor platforms, although some of these things certainly apply in the context of other platform firms as well. So early discussion of the so-called gig economy was heavily shaped by the company's own public relations messaging and often also funded research that emphasized flexibility and freedom, including for workers or service providers who provided services on that platform. Since then, the broader empirical literature on the gig economy has, bit by bit, been empirically confirming just how much control many labor platforms in fact exert over workers and their lives. These patterns of control and domination are now especially well documented in the ride-hailing sector. And I would point here to the work of Vina Dobal, as well as a number of other scholars who have documented this. While much of this control is mediated by, for example, passenger ratings or consumer ratings, not all of it is. And even the impact of these user ratings is determined by the platforms themselves. Just as importantly, platforms unilaterally set the prices that are paid by customers and the payments to drivers, and they determine how those payments will vary by factors such as geography, number of rides, or length of time that the driver is logged on, cancellations, and so forth. This is important because payment rates are then a direct lever by which the platform can control the number of drivers that are deployed in a particular area relative to others, and it can also effectively minimize or prevent switching between platforms by drivers, which is often posited as a check on the power of these platforms and is often posited as an example of why, in fact, competition is taking place. The control, however, so I'm just going to give you a little description of this control exerted by platforms that has been documented in the empirical literature. This control has mainly been discussed as a labor and employment law matter. It is starting to be discussed also as an antitrust issue. And the relevant area of law here is the law of vertical restraints. This area of law, as the name implies, is supposed to regulate the extent to which a firm can restrain the freedom of actors in adjacent markets with whom it contracts. And that's not just workers, that's any type of trading partner or counterparty, right? If the relationships between drivers or other workers or service providers on the one hand and gig platforms on the other are not regulated by labor and employment law, then by default, like all other contracts, they fall within the ambit of antitrust law and are subject, in theory, to the law of vertical restraints. Traditionally, the law of vertical restraints operated precisely to preserve the freedom of smaller actors downstream or upstream from more powerful firms, particularly where things like the prices they charge and the areas in which they operate were concerned. And so there were a number of cases dealing with this in the mid-century, for example, and these cases reasoned that independent business people, which is what the platforms claim that drivers and other workers are, should make independent decisions about how to run their businesses. And indeed, any value to maintaining nominally independent businesses is lost if they do not have the ability to engage in that decision-making, if they don't have true coordination rights, in other words. And the problem is that antitrust regulation of vertical restraints has been steadily eroding since the 1970s as this rationale of sort of maintaining independent decision-making, dispersing the right to engage in decision-making has been sidelined gradually in antitrust law. And instead, the rationale involving efficiency has come more and more to the fore. And the idea of this notion of efficiency, which was asserted in a growing law and economics literature, was that vertical restraints, namely, these controls placed by more powerful firms on these smaller actors in their orbits, that these vertical restraints are in fact efficient because they minimize costs, principally in distribution and supply chains. As economist Brian Kalachi has argued, however, the increasingly permissive attitude toward vertical restraints in antitrust law seems to have co-evolved to some extent with a then growing business form that relied upon such restraints, namely business format franchising. And I really recommend Brian's paper on this topic. And so this is also an example of how some of what occurs in the platform economy, it's not necessarily specific just to the platform economy. It's an encapsulation or dramatization of patterns of sort of how we allocate economic coordination rights or decision-making rights that obtain in other parts of the economy as well. So so applying this, back to the labor platforms and taking the firm Uber as an example, Uber and similar firms have not had to directly face this argument about the permissibility of the vertical restraints that they place upon drivers involving price, involving a number of other matters, partly because the path has been cleared for it through this pre-existing coevolution of law with another business model, but it too has made broad claims about its efficient business model, arguing for even more sweeping regulatory accommodations. Nevertheless, there are good arguments that an honest decision maker confronting even today's vertical restraints case law would find the labor platform's practices wanting. And that is partly because all of those classic vertical restraints cases, even the ones that liberalized the ability to place vertical restraints under the influence of the law and economics literature, all involved, for the most part, distribution or resale relationships. But Uber and similar platforms precisely claim, right, that drivers or others on their platform are not reselling something that they're selling. It neither is just by inspecting what's going on in the business model, that's not what it looks like, and they, quite overtly claim that that's not what's going on. However, as we'll talk about in just a moment, recent Supreme Court case law has ratified potentially an expanded version of a similar efficiency rationale that may grant license to platforms to exert almost unlimited control over workers. Okay, but before we move on to that, it's important to note that antitrust law, even as it has increasingly allocated economic coordination rights to dominant firms, to platform firms and others, has also prevented others in the platform economy, whether they are workers in labor platforms who find them, who are classified as independent contractors or independent business people, or whether they are small business people, for example, third-party sellers on Amazon. It has prevented these smaller third parties from organizing in order to exert collective bargaining power in their contracts with the platforms or otherwise. And so antitrust law has, I would argue, allocated coordination rights to vertical concentrated power in the form of these powerful platform firms, while denying coordination rights to horizontal, dispersed forms of association and cooperation among workers and other smaller actors. And the result is that platforms are frequently allowed to engage in coordination as to the very things, notably including prices, that are categorically off limits to collective action by drivers or other smaller actors in the orbits of the platforms. And ultimately, this allocation of coordination rights is justified on the ground that horizontal coordination of this type is inefficient, while the platform's coordination is efficient. Again, we don't even quite get to those arguments because the path has been cleared, through these earlier battles, but that is the ultimate argument. Overall, this rationale, which finds fullest expression in various Chicago School writings regarding vertical restraints and the resulting jurisprudence, tends to, I would argue, slip between what are in fact conceptually distinct senses of efficiency, a term we hear a lot in law school, right? So what do we mean by efficiency? So it trades between at least a couple of things. On the one hand, between the efficient allocation of resources that, according to the neoclassical model, is accomplished by competitive markets on the one hand, and on the other hand, operational cost savings that are realized by just technical efficiencies, by technically organizing production or distribution in a way that you realize technical efficiencies, right? I'll talk just a bit more about that. But even limited to this sort of sense of cost savings, the overall approach has been to just, to take what are really empirical questions about whether a particular organization saves costs or not, and turn it into just a legal assumption that is baked into different subject matter areas across antitrust law, I would argue. And an additional and distinct problem, which comes out particularly in claims about efficiency that are asserted in favor of loosening the law of vertical restraints. Now, those claims of efficiency are the claims of operational cost savings, right? While the claim about allocative efficiency, that's based on that neoclassical model that you don't want to distort the competitive process, that's what's deployed against the coordination of drivers or workers or labor unions or sellers on Amazon or what have you, right? So two totally distinct senses of efficiency. But there's a second problem, which is that even limited to that sense of operational cost savings, that which is what's really at issue with vertical restraints. The literature on this and the accompanying policy debate has not clarified where cost savings that are based in basically in labor discipline or in basically getting more effort for the same amount of money or getting the same effort for a less amount of money, when that's the claim of cost savings and when it's something else. And here, others who've written about this are economist Marshall Steinbaum, and I think Brian has as well. So let me just explain that point, because I think this actually goes way back in the debate, back to the first set of antitrust debates that occurred in the 1890s and the early 1900s. You see a version of this same debate. So a technical efficiency, right? Putting aside allocative efficiency, a technical efficiency is when you actually organize your production process or your distribution process in a way that makes sense, in a way that you get more for less effort, right? This makes sense. This is the fine goal of law. So nobody is saying throw out efficiency completely, right? Like if you're building a factory, you want to build it in the production process in an efficient manner. If you have multiple factories in your production process, it might not make sense to be flying parts from back from coast to coast, et cetera, et cetera. Organizing production and distribution in a rational manner, that is a technical efficiency. And we can be quite precise about this. This is getting more in this, but what do I mean by more? Output. This is one of the key concerns of antitrust law. Getting more output for the same effort. Because if I organize that factory in a rational way, if I organize that whole process in a rational way, then I'm going to get more output for the same effort than if I organize it in a very ramshackle way, right? But that is different, just as an analytical matter. Before we get to a question of what's good and bad or just or unjust, that is simply a different thing from getting more effort for the same money, because a technical efficiency, you hold the effort constant. But this is absolutely not kept apart in the conversation about vertical restraints, and this goes back really to the early 1980s, right? And so this, of course, becomes an argument for sweatshop labor, essentially. It also more subtly becomes an argument for squeezing small suppliers, small distributors, who then in turn are going to have to squeeze their own workers, right? So we can talk more about this, but I think that this is a really, really important issue that is starting to get some attention, but we have not, certainly in antitrust law, I don't think that we have teased out its implications. Okay, so many of the general efficiency arguments in favor of vertical restraints directly or indirectly imply that cost savings derived from what we can just now for shorthand call labor discipline, whether it's applied to small firms or workers getting more effort for the same price, right, or the same wage. These general efficiency arguments for vertical restraints directly or indirectly imply that cost savings derived from labor discipline are an element of the claimed legal operational efficiencies, right? It's not really ever made explicit in quite those terms, although sometimes you do see it. But when the same dynamics and arguments are transposed from distribution chains and franchising onto the labor platforms, it becomes more difficult to avoid this implication, because really we're now just talking about the provision of labor or services, right? But the logic is also present in those other contexts. And these labor discipline arguments, again, gain heightened salience under the official adherence to a consumer welfare standard, under which operational efficiencies are valued because they theoretically result in benefits to consumers or to all people in theory. On this view, riders, for example, to come back to the ride-hailing platforms, benefit from low driver pay, rendering restraints that result in low driver pay justified, and coordination that would tend to increase driver pay unjustified. However, defenders of the consumer welfare paradigm also frequently claim that it is simply shorthand for overall social welfare. But if that's really true, then it's hard to square with these claims about labor discipline or this very broad conception of efficiency that I mentioned before, right? It's not enough to say workers are also consumers, which is certainly true, but you hear a lot. At a minimum, there would have to be some type of empirical backing for the claim that low or mid-wage workers benefit on the whole from a consumer welfare paradigm more than they lose. And we don't really see that type of empirical backing for the paradigm. From a logical standpoint, certainly this seems unlikely, because low-wage workers are the smallest spenders, with most consumer benefits from low prices distributed among higher earners. If, on the other hand, the claim is that unevenly distributed aggregate welfare justifies turning sector after sector into sweatshop work by reorganizing it as a platform, then that's a much bolder claim, and is one that would likely to be rejected if we confronted it in those terms. Okay, so I think I just have a few minutes left, and I'm going to talk a little bit about Ohio v. American Express, because I said I would do that. So there's this recent Supreme Court decision that dealt with 2018, I believe, that dealt with the concept of two-sided markets for platforms. And this is a concept that's also frequently applied to the labor platforms and other platform firms in the economics literature. And this decision helps to extend and solidify the defining features of the antitrust treatment of the labor platform economy, which, as I sort of tried to argue, already prescribes market coordination in a manner that entrenches hierarchy and existing power disparities while stymieing democratic decision making. And that decision specifically does that by significantly expanding the previously accepted domain within which pro-competitive justifications for vertical restraints are essentially accepted as a matter of law, using this concept of a two-sided market or a platform to do so. So just really briefly to describe what happened in this case. In this significant and much discussed opinion, the Supreme Court held that contractual anti-steering provisions imposed by American Express upon its merchant customers did not violate Section 1 of the Sherman Act under the so-called rule of reason applied to vertical coordination. In essence, the relevant contractual provisions prevent merchants from encouraging customers to use credit cards other than American Express, even though American Express charges merchants a much higher fee for credit card transactions than most other credit card companies do. Applying the rule of reason under which vertical restraints are assessed, the court in American Express dispensed with the case at the first step of what's supposed to be a three-stage analysis, holding that plaintiffs had not shown that the relevant provisions of the American Express merchant contract had anti-competitive effects. In so holding, the court considered the attributed benefits of these provisions at the first stage of analysis, a move that the dissent in that case criticized as inconsistent with past precedent. So this is one of the ways in which it broke past even existing very permissive vertical restraints law. And then the majority made an additional key move that shifted this already permissive attitude. First, it suggested that market definition and the ensuing proof of market power within that market is required at the first step of the rule of reason analysis, even though prior precedent had held that direct proof of detrimental effects obviates the need to show market power. Second, and in reliance on the first move, the majority held that in the case of a two-sided platform, the relevant market must be defined to include the economic actors on both sides of that platform. For instance, here, both merchants and consumers who have American Express cards. So that means you can look at benefits to these consumers who have American Express cards and use that to offset the harms to the merchants. And then the final move, which is a little bit more implicit, but is, I would argue, perhaps the most significant, the court essentially expanded the traditional imputation of pro-competitive benefits that are assumed to flow from vertical coordination to an entirely new set of economic arrangements, namely these platform arrangements. So this is the part of American Express that I think is the least discussed. We talk about these other things a fair bit more, the offsetting the harms and the benefits across markets, etc. But as I mentioned before, all of the seminal cases that upheld vertical restraints previously on the basis of these efficiencies that they allegedly create involved manufacturers or wholesalers exerting controls over the resale of products that they themselves sell. And as the dissent in American Express said, a vertically imposed price fixing agreement typically involves a manufacturer controlling terms of sale for its own products. That's not the case in American Express, and it's not the case with Uber, and it's not the case when Amazon places restraints on third-party sellers or on others, right? And so this, so I think that this sort of means that this very permissive attitude toward vertical restraints, if it's extended in this direction, would just empower and make even, empower sort of this asymmetrical allocation of coordination rights that we already see in the platform economy and more broadly. So I was going to talk a little bit about what we could do about all this, but I think that since I think I'm at time, I'll just save that for the Q&A. Thank you.
Thanks so much, Sanjukta. and really looking forward to getting into that question of sort of what we can do about it, because I do think it's going to help illuminate some of the stakes of what you've just kind of laid out for us, this tremendously kind of powerful, I think, work that you're doing to help us see the world around us as strange in a way that I think that's what the most important academic work sometimes does. So really value that. And I guess I'll just say a couple of things about sort of how I first encountered your work and what I find so useful about it is I think one way to sort of reflect on what you're doing, and you tell me if this is wrong because I'm not a scholar of antitrust and labor law, but is that, you might see some of the central puzzle that you're working through really well displayed. And I think you've sort of invoked the ride hailing industry here in the kind of puzzle of something like Uber. Like, how is it that Uber gets to set all of these conditions of these drivers' labor and not be considered a price fixer? And yet when the drivers come around and they try to kind of coordinate themselves and negotiate with Uber, they are the ones who would run afoul of antitrust law, right? That's a very sort of arresting question, and I know one with which you've struggled. And the answer really is this, like, takes us through this tour of antitrust law. It's sort of, well, because Uber's a firm, and because the drivers are independent contractors, and so it touches on all these different kind of corporate law, labor law pieces, right? So like, part of what you're, I think, putting on the table is really sort of an autopsy, sort of like, how did we get there? We call this thing a firm, and then when we call it a firm, it gets protection from any inquiry about whether or not its decisions are price fixing or exhibit certain kinds of market power or so forth, right? Because it's a firm, and so it's just allowed to do all of this, and these guys are separate, and so they're not. I think relatedly, the piece about franchising that's so powerful is sort of how do we get to be in a world where McDonald's can control everything that's going on in a McDonald's, and yet avoid all of the labor law protections that might flow from the individual McDonald's employees all being considered employees of the same organization, which they aren't because it's a franchise. They're not in control, right? And so it reminds me of some of the sort of basic ways people talk about the sort of American system is, capitalism for the poor and socialism for the rich. That what we've done is deployed the protection of the that these companies can claim, Uber from any inquiry into its price setting, and McDonald's from any sort of labor law, by sort of like at different levels drawing the boundaries of where is a firm and where is it not, who's independent and who isn't, in ways that sort of consistently benefit bigger firms over smaller ones, and then that have all kinds of interesting implications for where we might go next. So I do want to give folks time to ask their questions, and so I really encourage you all to please put them into the Q&A, and then we'll turn to you. But I think I wanted to just start by asking you to talk a little bit about what the implications of thinking about the world in this way are. I've heard you talk before, for example, about the sort of remarkable fact that we live in a world where you're more likely, maybe as a church organist or a piano teacher, to be run into trouble with the antitrust authorities than you are if you're Uber or Amazon. Should that change? Should we not value competition as much as we do? Should we not be as concerned about price fixing as we are? Should we be much more leery of calling of allowing franchise, like the franchise holder to control everything going on without applying labor law to them? So I know you're thinking about all of these things. So why don't you just throw at us some of your sort of top line, what should change about the world in policy once we recognize that all of these sort of basic units of our analysis are open to and have been moved around historically and are open to sort of reorganizing?
Yeah, thank you. It's really helpful to hear it reflected back. And I'll try to say, I think that there's kind of like two types of reform that we can do, right? This won't be an exhaustive list, but I think there's two types. So one, and you brought up this idea about the firm. I didn't talk about it that much today, but right. So this idea of the firm exemption is something that I want to highlight in general in antitrust law, because it's, this is a unit of coordination that is naturalized, but that also then its applicability is quite ambiguous, and maybe should have highlighted this more. That's precisely one of the things that typifies the platform economy, is that it blurs or shifts the boundaries of the firm in some ways, right? So I won't go on and on about this. I've written about this if people are really interested in reading more about the firm exemption, but I do think that one of the ways to think about Uber and also Amazon, and actually even also Apple, arguably, is that they shift what the kind of earlier settlement of legal rights and responsibilities around the firm was, sort of at least from the New Deal era on, right? Because when I didn't sort of approach this historically at all in this talk, but in fact, these things evolved historically in these complicated ways. But certainly as of the New Deal sort of settlement, right, there, I think, was a trans-substantive understanding to some extent that there is going to be a firm exemption, effectively, that is, maybe seated in antitrust law in certain ways, but that transcends antitrust law. And so it's a deference to firm-based economic coordination, but that there are some countervailing rights that come with that effectively allocate back some coordination rights to workers through the Wagner Act, through labor law, through sort of a certain conception of mid-century managerial capitalism, where corporations had social responsibility to some extent or another, right? And really then one way of sort of longitudinally understanding the platform economy is taking the benefits of firm-based coordination, first of all, expanding those by sort of blowing up, I didn't talk about merger law or monopolization law, but like sort of blowing those things up, but others who, so obviously Lena Khan's paper on Amazon is really important here. But so blowing those things up, and then at the same time, sort of saying, oh, we don't have to comply with any of that allocating back of coordination rights. So specifically, it's most sort of obvious in legal doctrinal terms with labor and employment law, both in terms of sort of just directly who's an employee, but also exactly as you said, in terms of even if McDonald's employees are can theoretically organize, the McDonald's, the big corporation that actually runs the show across the franchise economy, doesn't have to bargain with them, which makes the whole point kind of moot, right? Okay, so but all of that is to say is that that's one line of reform, is kind of fixing that, like putting that back together, that sort of like that the firm exemption has been expanded. That one way you can, because the immediate answer to kind of the problem that you posed about Uber, right, is that well, they're vertical restraints, so they're efficient. So that's sort of what I was kind of trying to query. But Uber is already coordinating beyond the firm, and that's the way in which it's an expansion of the firm exemption, because it's not claiming, right? I mean, apart from the labor and employment question of whether these people are employees or not, if they're not employees, they're not in the firm, right? So you're beyond the firm exemption in that sense. So one line of reform is to kind of like line these things up, to make the sort of deployment of the concept of the firm consistent across labor and employment law and antitrust, right? So that's one line of things you can do. But I want to mention just briefly, I think another more ambitious line of things that we could do, which I think is actually consonant with the deeper anti-monopoly and antitrust tradition, which is to actually actively foster democratic market governance in various ways. So I don't want to like talk about it too much. I was sort of excited because I just read Blake Emerson's book on admin law, and talking about admin law as sort of a site for fostering democratic participation. And this is so applicable in antitrust, I think, right? Because, and even some of the historical examples of this, the FTC. So that certainly I would argue an interpretation of sort of the impetus for the FTC, certainly in Brandeis's vision, was to foster democratic market participation. And so what would that mean? So it would mean that, for example, the Federal Trade Commission or potentially other sector-specific agencies in other ways could actually bring together stakeholders in a particular market, small and big business, labor, the public, and actually, talk about and govern markets that way, right? So, and use tools like cost accounting. That was a big part of the original Brandeisian program, was getting rid of below cost pricing, because that's so disproportionately hurts small business and hurts workers, right? Clearly, if you're underpricing. And so stabilizing prices, but not stabilizing prices through oligopolistic firms necessarily, but stabilizing prices through democratic market governance. We could talk about what that could look like, but potentially you would have boards in different markets or sectors, right? And this starts to overlap with ideas about sectoral bargaining and labor law, supporting the point that it's all connected, right? But so that would be a more affirm. So then you're like kind of blowing past the firm exemption and actually, going for more democracy. So
I'm going to follow up on that and try to bring in a couple of the questions that have come in. So let's just imagine, so in that world, maybe you have a kind of a wage and labor board of some kind that says this is what a fair wage is and this is what fair pricing is in the ride sharing industry. And rather than allocating that question to Uber, knowing that it may be both predatory with respect to trying to crowd out competitors and extractive with this relationship to workers, you would want to try to settle that in some way that looks more kind of by democratic. I think in this context, we mean that both that like public values are accounted for and there's public participation of some kind, I would imagine, in that board. Is that the kind of thing that you're kind of getting at?
Yes, if I understand. So I definitely think public participation, like genuine public participation, is important, not just sort of the state as a representative of the public, but actual public participation and actual worker participation, both things that were largely missing, for example, from the experiment with this in the early part of the New Deal, for example.
And this is, I guess, I'm looking at Julie's question here towards the end of the Q&A, which is, so what's wrong with the argument that Uber is efficient? I mean, one way to ask this is, I guess, what's wrong with the consumer welfare standard? Like, isn't the right, why isn't it the right question whether or not Uber is lowering costs for people and efficient in that way, or maybe technically efficient in the terms that you use today? Is it really that you have, what an economist might call externalities, like there's these bad social outcomes, I'm
not seeing the question, sorry. I want to
pull up the Q&A. Do you have the Q&A in front of you?
Oh, not the chat. Sorry.
Not in the chat. No, we're asking you to use the Q&A, which is a good reminder. If you put your question in the chat, I'm going to pull them from the Q&A because I don't. So Julie's question is, when you talk about poking holes in the idea that Uber is efficient, are you thinking about the ways that low wages impact society overall, like the idea that low wages lead to bad social outcomes for health, safety, education, or is that oversimplifying what you mean by redefining efficiency?
Yeah, I mean, so I think that's true, but I think we have to move back from, like, before we even get to that point, right? Like, we have to ask sort of like so what's efficient about this and what isn't? So I think that it is important. I just want to return for a second to the point about distinguishing technical efficiencies from, I specifically, I chose not to say from exploitation or something else that's more normatively loaded, right? But just from sort of getting the distinction between getting more output per input versus getting the same input for a lower price. Those are just two different things. And the second thing is not a technical efficiency, right? Because there's no, I mean, so there's, even according to sort of neoclassical theory, getting the same input for a lower price is not necessarily efficient. That is not necessarily allocatively efficient, right? I mean, that's without buying any of the further critiques of neoclassical law and econ, just on its own terms. That's not the case. Why? Because there's no assumption that because what are you comparing it to? You're either comparing it to the current status quo or you're comparing it to some abstract normative benchmark, but we don't know what the abstract perfectly competitive price is. We don't know, right? We can compare it to what currently is, and by using what currently is as the benchmark and saying that anything that's lower than that for an input is efficient, that doesn't follow from neoclassical theory, actually, right? So, I mean, I think that is actually how I would answer that question without even, I also think it's true that low wages are bad for society and are, are not socially beneficial, but I don't want to actually jump to that point, because I want to deconstruct it on its own terms, so that it's, because I think that too often, I think that we've sort of assumed that this idea of efficiency really just means it's monolithic, it means something, it has these clear implications, but we need to counterbalance it with considerations of equity or humanitarian concerns or something, and that these are somehow separate. And I think that, I mean, I think not just me, but lots of people in LPE, I think part of what we're doing is kind of like trying to go into the foundation of it, right? So I don't know if that answers the question, but my attempt.
Great. So there was a question very early on about whether cooperatives are firms, and then a question from John Malthus that I see. What about a more decentralized system like driver-owned co-op Ubers? And I think that is an interesting counterpoint to what you and I were starting to discuss, is the democratized version of, let's just stick with Uber, is it more public control? Is that the democratic model, or is it more decentralized control with small, let's say, either smaller business, right, or nonprofit, co-op kinds of business?
Totally. So no, it's a great question. So first of all, I just wanted to give that as an example, the sort of democratic price boards as one example. I don't think that's necessarily the thing to do for every sector, nor do I think it's inconsistent with promoting co-ops and cooperatives generally. Because I think that there could be a policy of promoting co-ops, and then co-ops become among the stakeholders for whatever sort of higher level management of the market needs to occur. But so this is a really interesting thing. Do cooperatives count as firms? It depends. Actually, this is sort of one of the interesting things, is that antitrust law doesn't just defer to sort of what a particular state business association law says about whether something is a firm or not. So it's very clear that simply incorporating is not sufficient to get the firm exemption, right? Antitrust law does a more searching inquiry, and then if you look at what the case law says, it kind of it turns out that what it looks for is concentrated top-down control of the type that we're accustomed to in sort of a traditional investor-owned corporation. There's not a case I know of that says a cooperative's not a firm. That's not the case. And certainly cooperatives that are sufficiently integrated, and cooperatives that potentially are worker owned, but that delegate all management functions to hired managers, those would almost certainly qualify. But looser cooperatives would not, because looser cooperatives would be called by the law incorporated cartels, right? We haven't sort of fully tested this, but that's what you sort of get to if you read the case law and then think about these different forms of organization. And so, for example, thinking about this with Uber drivers, if they didn't centralize the ownership of the cars, for example, which is the productive asset, and there wasn't, and essentially they incorporated for the purpose of basically being a bargaining agency, and maybe creating an app together and all participating in that, it's not at all clear that that would qualify for the firm exemption and wouldn't be prosecuted. I think it would certainly make this discrepancy that we've been talking about that much more stark, and it would force decision makers to grapple with it. But I think it's not a straightforward point. The other thing is on the programmatic side of that, though, yes, I think that sort of more clearly permitting and even promoting those structures should be part of how we redress this imbalance, I think. That I think should be, can be even more affirmative than changing the antitrust rules. There was my friend and colleague Nathan Tinketts and I wrote a short essay on how finance and antitrust rules actually intersect here. So, for example, cooperatives like this would have a harder time getting financing, and that affects their ability to compete, right? I mean, so we've seen that in a lot of the emerging antitrust literature, is that part of what these big firms have is access to capital and the ability to engage in low pricing and to sort of outcompete in that way in ways that aren't necessarily socially beneficial. So cooperatives lack that, and they lack that partly precisely because one of the benefits that you promise to investors eventually is that you're going to gobble up market share. You know, that's what an Amazon or an Uber is promising to its early investors, presumably. And so these, I think that these issues of finance and the antitrust rules of allocating coordination rights interact. And I think that we should go further than changing the antitrust rules, arguably, to actually thinking about public financing for cooperatives, for cooperative structures. And then there could be, and the final thing is that I don't know that it's like one or the other in terms of public control versus devolved, because I think that part of what's exciting about sort of like the democratic participation through administrative agencies and organizations, it can be actually pretty devolved, but still having a public role, right? It can you know, involve trade associations, labor unions, worker associations, co-ops. But I think that there's obviously important policy design issues to think about actually making this democratic.
I mean, I think that part of what this is paralleling is a broader kind of conversation that is happening, and I think we need to have more attention to in conversations about law and political economy, which is when we say democratize, how much of this is rendering it more publicly accountable, let's say through participatory institutions, and how much of it is kind of returning things into a kind of, you know, kind of pre-neoliberal state where there's a kind of less monopoly, say, less concentrated power, where democracy might be the presence of many small players. And I think, you know, sort of thinking about the stakes of like, do you democratize by making decisions about financing, or do you democratize, you know, so your idea of like public financing of cooperatives, there some of the key decisions are made by the people who finance, or do you democratize through things like, you know, a kind of a local board that might have something to say about what appropriate, you know, kind of labor and market, you know, considerations are. Yeah, that's very, very important, interesting conversation. So I wanted to come now to another question that actually is at the top of the Q&A, which is to bring us into the realm of property rights. So Gautam is asking, you know, in this particular context, Uber claims a property right over the app, and that is helping it, in fact, engage in price fixing. It's also helping it disguise that, you know, how it's, I mean, this is something I've been very much working on recently, you know, that claims to intellectual property, and in this context, some trade secrecy or just simple secrecy actually operate very much to the advantage of those inside of a, you know, organized firm. So how do you think about the relationship between property and the dynamics of consolidation and power that you're talking about?
It's a super good question. I'd love to talk to you more about it. And Hiba Hafiz has a new paper out on IP and antitrust, I think. And I haven't read the current version, but I think I meant to mention this during the talk, actually, that is, I think, another important thing about these efficiency justifications is that they, you know, they sort of arguably originally migrated actually from master servant law to economic theory to antitrust, but then they also migrate back to labor and employment law to provide defenses to like joint employment, for example. I think Hiba's paper, and then a new paper by Andrew Elmore, which is not about IP, but about this, you know, applying antitrust efficiency defenses in the employment context, demonstrate this. I wanted to mention that. But yeah, so I would let you speak to the IP part. I think that this is clearly bound up with the deeper questions, though. For example, in what I would call the firm exemption case law, which is not what it's called, but the single entity case law, property is definitely sort of like one of the indicia of sort of, and that's true in vertical restraints too. So, you know, I think it is definitely a factor that favors deference to coordination. But it doesn't have to be property. I think that's the weird thing about vertical restraint. At a certain point, there's this self-justifying character to the control, truly. I mean, it sounds like a cop-out to say, but I think it's true, because I think that because I don't think it's just property. I struggled with this at first, but it's if there is enough of sort of like an existing control center that looks like property, even if it's mediated through contract, then I think that that starts to like attract legitimacy, and so I think that that results in this sort of self-justifying character. But definitely, property, I think, is the gold standard. And in fact, I think even I think there's some, I'd have to look at this more, but I think there's even some basis to say that property gets even more special treatment, because it's you even sort of there's even justification to suspend questions of efficiency where property is concerned, so that there may be kind of a even a two-step between efficiency arguments and sort of implicit natural rights arguments. Not exactly natural rights, but that those are really self-justifying.
Well, I think there's lots more for us to talk about there, and we should definitely follow up on that. I was looking at a question at the bottom, which comes from Luke. If the top-down management, so following up on your point that cooperatives might not be seen, even though they tried to constitute themselves as firms, might not be seen as firms. If top-down management of economic coordination is considered a prerequisite to the firm exemption, if there really is a kind of, I think, idealization of hierarchy itself, I think, as you were describing, what is management? So if a salesperson employee negotiates a price with a client, are they managing economic coordination? What exactly is management in the eyes of antitrust?
Yeah, I mean, I don't know if I can answer that in a fine-grained way, but I think it's worth bringing up vertical restraints again here, because part of what occurred, right? I mean, because I think in a way that speaks to this question is that when so in the context of vertical restraints, when, for example, the agent of the corporation that deals with the regional distributors, when they are dealing with the regional distributors, even though those regional distributors are not employees, what effectively happened, I think, in the literature that favored sort of the liberalization of vertical restraints, is that an employment-like justification, like basically a Coasian, sort of the idea that like, so in one sense, like what underlies the firm exemption, right, is that for what firms do, they're efficient, because because on some level telling people what to do is efficient when it's efficient, although sometimes contracting is more efficient, right? But that itself, sort of posits those as the two options. But it was extending that employment-like imputation of efficiency beyond the employment relationship that constitutes the firm to these contractual relationships between, for example, like a big oil company and a small gas station that is selling their gas, and essentially saying, giving them the ability to control those smaller actors in their orbits more, is potentially going to create efficiencies. Again, not really in the technical efficiency sense, but in this sort of, there's actually, again, my colleague Marshall Steinbaum, I think, found this quote from an economist at the time, who was, then quoted in some of the vertical restraints case law, that it's that certain vertical restraints are efficient essentially because you'll get the distributor to work harder if he's under, for example, an exclusive contract, and that's just a perfect example of this.
Great. There's a kind of interesting foundational question from Susan that I wanted to bring now. I think this might be our last one. We'll see how quickly we get through it. Early on, you stated that underpinning much of the law is the assumption that economic competition leads to optimal outcomes. So what's the definition of optimal outcome? For whom will it be optimal?
Yeah, so yeah, this isn't my view, but it really does, I think, underlie sort of a number of these areas of law, and certainly antitrust law, contemporary antitrust law, not historically, which is the idea that that sort of social welfare will be optimized. I mean, there's so many problems with this. It's hard for me to really defend, but that is sort of but that's the idea, that sort of if
right. I mean, the optimal is what's efficient, basically, right? I mean, typically in these kinds of arguments, right? And then the question becomes what kind of efficiency and so forth.
Well, yeah, it would be the allocative sense of efficiency for that. But yeah, I mean, that's restating it. But not sure how to answer further.
Well, and I guess I wasn't sure actually that I thought maybe one thing that the question might be gesturing at is what do you think the optimal, like if we're at, you know, if we were to redefine the optimal, like what is the optimal that we should be aiming at when we're deciding, you know, what would be pro-social, or what would be, you know, like how do we define optimality? I guess part of what you said earlier, where there might be a role for efficiency in that analysis, but a different kind of efficiency, a role for democracy. So how do you think we ought to define the optimal that we're trying to get at with antitrust law, labor law, and so forth?
Yeah, so I definitely wouldn't try to redefine optimality in terms of aggregate welfare, because I'm just not invested in that framework at all. But in terms of sort of affirmatively what the criteria should be for organizing economic coordination, we should absolutely think about that. And so I would say there is a role for efficiency, but not the efficiency that goes with sort of optimal outcomes, but with operational efficiency. And then further, operational efficiency in the true technical efficiency sense, not in the sense of getting the same thing for a lower price. I think something I didn't get to in this talk that I think is important, that doesn't mean that higher prices are always better either, right? That's not the point. It's that there ultimately has to be a working out of fair prices. And the thing is, this is why the democratic price boards, I think, are an important piece of the picture, or some form of sort of democratically thinking about prices, because once you really let go of the idea that there is an optimal price that results from whether it's the neoclassical idea of optimality, or whether it's a more sort of common sense of whatever happens in the market, that's good, right? Which is kind of the folk sense of this in a way. But once you let go of that, because you fully appreciate all these background legal and political decisions that are determining the outcome in the actual marketplace, or the theoretical outcome in the textbook marketplace, right? Then you actually have to have some other way of thinking about prices. And so to answer the question, I think technical efficiencies are a fine criteria to think about how to organize economic coordination. I think that the I think that the determination of price and other things, other elements of output, all the other sort of decisions that are being made should indeed be more democratic. I think we should disperse economic coordination rights rather than concentrating them. That I think there's a space for co-ops, for small business, for traditional labor unions, and also for sort of proactively something, something that's more sort of proactively public. But the other piece that I think is really important is thinking about pricing in terms of costs and in terms of what is fair. And this was actually in terms of fair given those costs. And that actually involves this very prosaic enterprise of doing proper cost accounting, right? And this was actually, again, part of, part of what Brandeis, for example, not that he's sort of the ultimate reference on all of this, but if we're talking about sort of what the FTC, for example, was supposed to do, this is something he was, for example, very invested in. And so I think that the idea of fair prices and prices that are based on, sort of properly based on costs, which includes fair labor costs, are intertwined. So I think it's some combination of those things, like democratic allocation, technical efficiencies, cost-based accounting. I'm sure there's others, but those are the three that I tend to think about.
I think we are just about at the end of our time, but I might just throw in one last question there. Do you think that what are the implications of the recent ruling in Britain on Uber's claim that its drivers are not employees, or broadly? I think people are paying attention to the Uber litigation, and sort of how do you think that plays into these discussions?
Sorry, what was the first part of the?
Oh, well, this person was asking about the ruling in Britain on Uber's claims that its drivers are not employees and whether it'll have an effect on U.S. litigation. But I am also thinking more generally, how do you see the litigation over Uber's employees, can claim that that these independent contractors are not employees? What role will that play in the dynamics that we're talking about?
Yeah, I mean, it's good to bring it up because that's why. this example, in a sense, I mean, the discussion operates sort of like, from the premise that arguendo, let's pretend they're not employees, but in fact they clearly are. Like, the amount of control that Uber exerts, right, makes, I think, this not a particularly close case in terms of, because this is a place where we could sort of, like, in this micro sense, we could pursue different reform programs, right? We could either sort of like democratize their coordination rights through a traditional labor union by making them employees, or in sort of other non-traditional ways. I still think we can promote driver co-ops, and but then they have to genuinely be co-ops. I don't think that sort of has to be an either or, but I do agree, if this is sort of like behind the question, that this isn't a place where sort of liberalizing the antitrust rules around coordination itself needs to, is the biggest issue, because I think that, in fact, if Uber is to continue operating sort of the way that they, in something like the way that they do, that they will need to make them employees. But I think it's, again, important to see that as part of, still what you're doing. It's not opposed. They're still going to end up having a greater voice in market governance through a union, assuming that they're able to organize, which is the goal of a lot of them.
Right. Great. Well, we're at time now, and I'm really, really grateful for this really rich conversation. Sandrika, thanks so much for joining us, and to our whole audience for your excellent questions. We do have one more program. Yep. And I know, Russ, that you wanted to, I'm also going to just throw in, for those of you interested in more law and political economy questions, I'll just throw into the chat how to find our website. And Russ, did you have some last things you wanted to say?
Thank you so much. This really was a fascinating program. And thank you so much to Sanjay Gupta and Amy for doing this. And I want to thank the audience for joining us. And all I want to do is just invite everyone to join us again for the next session on LPE on April 9th at 4 p.m. Eastern Time, when Lev Menand will discuss law, money, and banking. And the details on that can be found on the ACS and LPE websites. Thank you, and have a great evening.
Thanks, everyone.